Unemployment law in under 5 minutes. We're going to explain South Carolina unemployment law to you in under 5 minutes. First, an overview. Unemployment is a system of benefits, money to help workers and their families avoid the negative impacts of job loss. It's temporary, and it's designed to bridge the gap until the worker can find a new job. The amount of unemployment comes from a formula based on wages you've earned in the last 15 months. Part 1. Eligibility. There are 5 requirements to receive unemployment. 1. Earnings or monetary eligibility. This means that you must have made a certain amount of wages over the last 15 months. You can find the exact amount at the SC Department of Employment and Workforce. 2. You have to be able to work. 3. You have to be available for work. 4. You have to be actively seeking work. This includes a requirement that you search for work through the Department of Employment and Workforce website each week. 5. And finally, you need to have separated from your job for certain reasons. You don't qualify for unemployment if you voluntarily quit, unless you can prove you had good cause to quit. Good cause to quit can be very hard to prove, so it's a good idea to try everything you can before quitting a job. You were discharged for cause. For example, if you were often late or made many careless mistakes, you still qualify for unemployment if you were unable to meet the employer's goals, or if you didn't have the skills to do the work. You were discharged for misconduct, like theft, damaging equipment, cursing at a boss or coworkers, or you fail a drug test. There are a few exceptions to these rules, such as if you had to leave your job because your spouse's job was transferred to another city, you are a victim of domestic violence, or because you or another family member is ill or disabled. You may still be eligible for benefits in these situations. Part 2. The process. You apply for unemployment on the website of the South Carolina Department of Employment and Workforce. In the application, you will answer questions about why you were separated from the job. The agency will contact both you and the employer to ask more questions. Then they make an initial determination, which they will mail to you. This will state whether you are granted unemployment or not, and why. If you are denied, you only have 10 calendar days to file an appeal. That's 10 calendar days, including weekends. The clock starts ticking on the day the determination was sent, not when it was received by you. If you miss this deadline, you have lost your appeal and you will not get unemployment. You can send the appeal by mail, online, or by fax. To prepare the appeal, first, contact legal aid. You may qualify for free help. Second, request a copy of your claims file from the department. Third, gather evidence to help you prove your claim, like witnesses who can testify that you were actually terminated and did not quit, or time records to show you were not late. Fourth, the hearing will be held by telephone. Send your evidence to the department and the employer 24 hours in advance. The hearing is like a miniature trial, where the hearing officer is trying to figure out whether you are eligible for benefits based on the evidence. At the hearing, be prepared to tell your side of the story. Have your witnesses present to testify, and ask that any evidence you sent in be considered. Unemployment cases can be hard to win on your own. Contact SCLS at the earliest opportunity to see if we can help.